SJC-13669, William P. O'Donnell versus John J. Cronin et al.
Okay, Attorney Siegel.
Chief Justice Budd, Associate Justices, may it please the court, Joshua Siegel for the appellants. Superior Court committed error in awarding the Register of Deeds summary judgment on his claim that as an authorized official or department head, the Registry of Deeds, he was permitted to make transfers between budget subclasses without even having to justify or articulate the basis for his opinion that public necessity and convenience required the transfer. The county budget process is set forth by the statute in an exacting way that involves the Democratic County Budget Advisory Board. It presumes good faith.
I get all that. How do you wrestle with the words "in his opinion"? Very odd language to include in a statute. Doesn't say, you know, if he provides a reasonable basis or whatever. It just says "in his opinion."
So the opinion has to A, exist, and B, there's implicit.
We know it exists because he did it. He says, in my opinion, it's a public, what is it, public convenience or
Public necessity and convenience, Your Honor.
So he says, it's my opinion, it's a public necessity. Don't you lose?
Implicit in all laws, Your Honor, is that government has to act rationally.
Yeah, but a lot of laws, most laws use the word reason, reasonable basis. This is just an odd expression in a subcategory of expenses.
It is an, I concede that it's an odd expression, Your Honor. Certainly, though, the opinion, and saying an opinion exists and actually holding an opinion are different as an initial matter. So saying I'm of this opinion.
Like a fine distinction. I'd like you to help me out on that one.
Sure, and I think, and that the response here by the county was, explain this opinion a little bit. Tell me why you have this opinion, and the response was to file a lawsuit. It wasn't to say, oh, you know, I don't need the computer technology, computer hardware for this or the other reason. There's an exacting budget process that existed here. There's a presumption of good faith in the statute that county officials will act with good faith. And when there is a question about that, the implicit rationality that is there in all statutes, and I said in the brief about equal protection, we have that. Agencies have to be rational, the legislature has to be rational.
But where does it say that he has to respond to your clients?
The statute does not explicitly say that he has to respond to the client. That's implicit here, and it's implicit in the way
From what is it implicit that your clients have any authority to review, that was your word in your reply brief, to review the discretionary act of the register?
It's implicit in the way that the county officials process and handle the budget and the overall statutory scheme there, because
Well, isn't it actually explicit in the statute that your clients do have a say for certain transfers? It's very clear, right?
There are certain transfers that require a vote by the county board, yes. But there has always been a practice of approval by the county. And if you look at any of the transfer forms that were submitted and that are in the record, there's a line that says approved by.
Getting along is great until you don't.
And of course, that's why we're here.
So let me ask you, you talk about unbridled discretion. It seems to me that there's, you know, this petition to the SJC enforcement mechanism, right, by taxpayers?
By the taxpayers or the Attorney General.
Right, if there's something askew. And then the extreme, or supreme rather, check on discretion is the ballot box, right?
Well, that's only in this particular case. That's not in the case of most authorized officials under the statute. Most authorized officials under the statute are employees. And that's why this is a...
But yeah, that's why you have, in my opinion, an uphill battle given the words of the statute. You call them magic words, but they are pretty darn magic.
The implication of that, Your Honor, is that any town official, authorized official, department head, the head of facilities, the head of maintenance, you know, the Register of Deeds, can make these transfers, and the only way to stop it is by having a taxpayer or the Attorney General file a lawsuit about it after it happens.
Or to vote the person out. So if the voters say this person is raiding the IT fund to fund litigation, we don't like that, they vote him out.
The only person that, they can't vote out most of these authorized officials. Most of these are not elected positions. So the head of HR or maintenance is a hired position, and
At will?
I think it depends on the position, but I believe most are not union positions. It's not in the record, and I don't know candidly, Your Honor, but that's my understanding. And so the county directors have that check against most, if not everyone else, who this covers. And so to say that the ballot box is what the legislature intended as the check on this is not accurate, Your Honor.
Doesn't it seem like the legislature intended some degree of flexibility in moving money from one subgroup to another subgroup? At that level, there needed to be this flexibility without going through the rigmaroles required to transfer funds between bigger groups.
Yes, Your Honor, there was that, and I think the better example for that is if you look at the record, there's only one transfer in the record that does not come from the Registry of Deeds, and that's a transfer between snow removal and electricity. It's on page 394 of the record appendix. And it was a transfer where the authorized official sent an email saying, in May of the fiscal year, which I think was May of 2023, fiscal year ends at the end of June, saying, can you move money from snow removal to electricity to pay the attached bill? There's the justification already in that email. It's May, so there's not going to be more snow removal before the end of the fiscal year. And this electrical bill that's being attached needs to be paid. Implicitly, there's not the budget money to cover that. So yes, there is room for some flexibility, reasonable flexibility, and simply saying, what is it if it's not obvious from the exchange, and the only exchange that we have in the record that's not from the registry made it very obvious, shows that that's how the process worked. The forms all say, and the practice has been in the town, there's no evidence to the contrary in the record, that the transfers had to be approved by someone from the county, and that's why it says authorized by and date on the bottom of the transfer forms, and that was in all the samples and the ones submitted by the registry and elsewhere. And there is an administrative process for approving these. To get an administrative process completed,
Whatever the practice is and the process that's been built up over the years, we have to go back to the statute, correct? That's our legal standard.
the statute, as understood in the context of all statutes understood, that that government officials have to act rationally.
And also that they're going to work out minor differences and not involve the courts. And this kind of intramural fighting is something that maybe the legislature said, you should be able to work this out at this level, and you shouldn't be in court fighting this crap over.
I mean, as the defendants representing the defendants in all the litigation at hand, our preference would be not to be at the courts as well, Your Honor.
Right. And I get why this looks a little different than the normal transferring between sub-budgets, because he's suing you. He's suing your clients with this money. And I get this may be different, but unfortunately it meets the exact statutory requirement of intramural fighting that we're not supposed to be getting involved with.
Your Honor, to take this out of the courts entirely and leave it to the voters?
Well, no, the legislature said basically mature government officials should be able to work this out among themselves because it's usually minor budgetary transfers. Now, I get it. This fight is escalated where this money is actually being used to sue your clients. And I can see why that's upsetting. But it just, I don't see a way around the statutory language.
It's not only that it's being used to sue our clients, it's also that the requests have been made for additional funds for that purpose. And by the elected officials in charge.
Could you have gone to the Attorney General's office and asked them to enforce this, Section 35?
The statute is, to my knowledge, not been interpreted. This section 35. Yes, that says the Attorney General can do this. I think it is only after the fact. So if we made the transfer and then went to the Attorney General and said, hey, please sue us, the county, to stop this transfer that was already made, conceivably, that could, I don't know, Your Honor.
Maybe
That
you're not
is-
supposed to engage in self-help.
Your Honor, this is, I think it's important to remember the context at which this came. The request was made through the appropriate channels. The vote was denied, or at least in the amount requested, $60,000 additional dollars requested, $20,000 got there. And immediately, the authorized official said, well, then I'm going to transfer this money. And the county director said, you requested $180,000, I believe it was, for computer technology. We are 4 months into the fiscal year. How are you going to deal with this? What's your plan? And instead of responding and saying, here's why I think we need this, here's why it's in the public necessity and convenience, the response was to file a lawsuit. If there had been a response that said, oh, turns out I had a hardware analysis done, I looked at the computers, they're great, and here's why I need the money for these other reasons, and both sides, where it's coming from, where it's going, was explained.
I'm not sure how useful it is to engage in this hypothetical. I mean, something specific happened, which is that $60,000 for legal fees was requested, and then only $20,000 was authorized. So there was an effort to reach out on this, and then the register got a third of what was requested, correct?
Yes.
So I'm not sure how useful it is to hypothesize that if the register had just asked nicely, the register would have gotten the money.
I think it's a different case if the rationale is provided. And then
But does it need, but I don't understand why the person would need to explain why the funds were no longer needed in category A, in this case, computer hardware. Because it seems to me the whole scheme is designed to say you have a greater than anticipated need in category B, therefore you have discretion to transfer funds from category A to category B. I don't see anything to indicate you need to show that you don't any longer need the funds in category A. It may be that you need the funds in both categories, but that the person making the request is trying to satisfy an unanticipated need.
public necessity and convenience requiring the transfer requires both aspects. There's nothing that says only where the transfer is going. It is both aspects of the transfer. Managing a budget, of course, requires taking from and transfer, in this, taking from and going to. And the public necessity and convenience language says transfers within an appropriation between budget classes, between subclasses, may be made whenever, in the authorized official's opinion, public necessity and convenience so requires. It's the transfer between. So it is both from and to. And if both of those lines matter, there has to be a reason for it, there has to be a rational reason for it. County officials are required to act rationally. The implication that this can happen without any check not only involves this underlying lawsuit, but also opens the county up to being sued under Section 35 by the taxpayer or the Attorney General.
I have a question about your argument on the relief, the piece of the relief, which is you say you can't satisfy essentially the part of the order that requires what I would say specific performance. It doesn't seem to me all that appealing to think that there's just no relief, assuming that the question of liability was correctly determined, right? So what would have been the appropriate form of relief? An actual judgment, which you could then pay out of a subsequent fiscal year?
No, Your Honor. I think a declaration that this category of transfer is required, so to speak, is the relief. And in fact, what happened was after the motion practice and the single justice practice involving the question of whether the transfer had to be made, the transfer for fiscal year 24 was authorized after the court was allowed. And
Okay, so does that moot the argument, your argument about the issue of whether the relief could be satisfied?
The specific transfer in FY '23 could no longer be satisfied legally. That's why the case is not moot overall, because this is a matter capable of repetition, and the clarity the court provides will.
Okay, on the question of liability, but do I understand you correctly to be saying that there's no issue with the money anymore?
We contend that FY '23 has been closed, FY '24 has been closed, we're now in FY '25, so we can't.
But have you transferred the money to
There was a
him?
transfer among budget allocation lines in FY '24. I don't believe that money was actually spent in FY '24. If there's a request in FY '25, whether in these budget classes or other budget classes, and I don't have the FY '25 budget at hand or in my head, then based on the court's guidance, those transfers will be made or justifications will be required.
Well, hold on. The order that you're under, as I understand it, because your stay was vacated,
Yes.
is that that the declaration of the Superior Court was that any actions on the part of the defendants to interfere with transfers with an appropriation between classes and between subclasses are arbitrary and capricious and contrary to law. So if you, unless and until this court issues a decision, you will not be interfering with transfers.
Correct,
In
Your
those. Okay, thank you.
Okay,
Thank
thank
you.
you. Okay, Attorney O'Donnell.
Chief Justice's Associate Justice, good morning. May it please the court. My name is Bill O'Donnell. I'm here in my capacity as Register of Deeds. I was forced to litigate this case pro se due to the actions of the county defendants. I urge this honorable court to rule the same way as Judge Cahill Lane did in the Superior Court, where he gave a comprehensive and detailed decision and order as it relates to two summary judgment rulings made, one that was filed by myself as register and the other filed by the county defendants. The Supreme Judicial Court should rule, as did the Norfolk Superior Court, based on Massachusetts state law, as well as the court record and the facts in that record. There is no genuine issue of material fact in this matter. As a matter of fact, Chapter 35, Section 32, it has unambiguous and very clear language. The plaintiff, appellee, has met its burden. The registry transfers were singled out and unlawfully blocked by the defendant, County Director John J. Cronin. Remember, there were 4 transfers. One of them is the only one that involved legal monies, but all 4 were blocked. The defendant, County Director Cronin...
Do we have the original, I'm taking a step backwards for a second. There's an original lawsuit between you and the other part of the county. Do we have what that lawsuit's about? Is that for hiring for IT security?
There are 2 aspects, and I would urge the court, since this was taken sua sponte, Judge Cloutier on June 28th ruled in favor of the registry on at least 5 of the counts, what the counts were. And remember, we did have an attorney. We had...
Is it in the record that we can determine what that original lawsuit was about? Because you were asking for funds to pay for that lawsuit. Do we know what that lawsuit's about?
It's in the docket. The docket was part of the record appendix that was put together, but I would also urge, since that record appendix, if you could look at, the decision came down on June 28th, and it outlines, it's not just the register's right to appoint, which Judge Cloutier ruled favorably, but also it involved the misappropriation
To appoint an IT security person? I'm just trying to understand if there's a relationship.
Yes, for years, the registry had a chief information officer, information technology, which served the county as well as the registry because they couldn't afford it. Then there was I don't agree with this decision, but they eliminated the on-site direct report IT person at the registry. But before they made that decision, the register had submitted, someone had retired. There was an approved and funded budget, and had approved I submitted the IT. Judge Cloutier ruled that an approved and funded position, that appointment should have been respected. But more importantly, and again...
Mine's a sort of a basic understanding of background, but he's arguing that transferring money out of computers when you need computers is sort of on its face problematic. But if the lawsuit itself was about computer safety and technology, there may be more complexity to that.
There is more complexity, and it's kind of disingenuous to say that when the county director who's blocking all this told us because there was a vote to eliminate the registry IT department. Now it's all under the county, that we weren't going to be able to access that money in the fiscal year. But more importantly, the other aspects of, and this is where I get into the unclean hands of the defendants, the other parts of that lawsuit dealt with taking, using deeds excise money that statutorily belongs to the registry and paying $2.5 million of county obligation. Then while the litigation was pending, there was $4.3 million that had accumulated under a statute from prior registers than I that they just took. And Judge Cloutier ruled that violated Chapter 64D, Section 12, A, Section 11, and as well as 12B. They're supposed to give a county mandate to the registry. So it's not just about the IT. To me, they didn't want this case prosecuted in court. And we had Attorney Keston, Brody, that firm had filed a complaint, an amended complaint that was allowed by the Superior Court on September 9th, 2022. And then lo and behold, after that's allowed, all these transfers start getting blocked. And I would argue it's retaliatory actions because they were trying to chill the registry's right to have counsel. And eventually, I had to do this pro se, but eventually Attorney Keston, and I'm not going to hold an attorney to do a law when he's not getting paid. He was getting paid through the, as you say, playing nice in the sandbox here, and the bills were getting paid. Then they weren't. And again, to me, the whole case really is about a clear statute where the county director and their employers have no way to prove that they are the authorized official of the registry. They might not like my opinion, and they might not like being sued, but again, they're also arguing that this decision should be overturned because it's meritless. If it's so meritless, why did Judge Cloutier on June 28th, and also she denied the reconsideration in August? I would urge people to read that decision because it involves millions of dollars. And again, I think that's what motivated a lot of these decisions to prevent us from having counsel. As a matter of fact, and it's in the record appendix, one of the county defendant's officials made a statement, or words to the effect. It was caught at a mic, and Attorney Keston put it as part of his record, and it's part of my affidavit. It's in the record appendix, where the county official said, if relative to legal fees, if we don't fund it, possibly the case will get dismissed. So this case, I had to file this because, we wanted access to justice. And again, I think Chapter 35, Section 32, it's really the rules of the road after an approved budget. We went through a process. I think the appellants say in their brief how vigorous the budget process is. Once the budget gets approved, it gets voted on by the county commissioners, it gets voted on by the county advisory board, which is like our town meeting or city council. Then the legislature, I think, very clearly and unambiguously, Judge Cahill Lane, twice in his decision said this is an unambiguous statute. We're allowed, if we have an opinion, to move monies within code. And I think, government should be run efficiently. Government should be run soundly. And I think this statute really is a reflection of the legislature coming up with the rules of the road relative to someone who's a department head. And, again, we just want to be treated like the other department heads. In the past, things were routinely posted. I think what changed was the lawsuit. But please remember, 3 of the other, requests were done. And I think it was all done after that September 9th motion that got allowed by the court. It was done as a pretext to again, deny us access to justice. And
Excuse me, counsel. Could I ask, you've referred a couple of times to the fact that only a chunk of it is for legal fees, and then there's the other chunks for miscellaneous contractual services and miscellaneous professional and technical services. Is it anywhere, I know that you're asserting that those don't have to do, standing before us today, that those don't have to do with the lawsuit, but is it at all in the record what what those are for?
Yes, for instance, there was a small amount made, my first assistant, first female register appointed, she makes a request because, I delegated to her to do it, $3,000, part of which was $1,500 from mileage that I don't take.
Well, hold on, is that in the record, though?
Yes, and all those requests are the record, and you got to understand, she had a toxic work environment complaint against the county director. So on that one, I think it was two reasons going on, the lawsuit and also to send a message to my first assistant that you don't make toxic work environment complaints against County Director John Cronin. But each of the requests are in the record. They were attached
No,
to the complaint.
I saw the requests for authorization, but what I didn't see was what the money was supposed to be for.
I apologize. We did address some of that in the brief. For instance, that first one I mentioned. Again, using money, it was mentioned earlier that we're not using and moving it to other accounts that we do. The other contractual services, it was used for data storage. It's used for something as simple as water for the employees or papers and pens.
But is that, I read that in your brief, and I noticed that you didn't have a citation to the record. So I'm just wondering, did that make it into the record in the court below, what that money was going to be used for, if transferred?
Well, again, I know one thing that made it into the record because they're trying to say we didn't justify it. And we did justify all the transfers, I believe, on the record. But I would say also, here's a letter. I would refer to Record Appendix 241, 242, 243. This was a July 7th, 2022 letter that was sent to the commissioners and to County Director Cronin. I, in this letter, did substantiate or justify my opinion to those that think it's required. I believe that the Bolter case just says there's an opinion that's needed. But in that letter, we did say, for instance, reading from it, relative to legal fees, it represents a humble appeal for the removal of any and all financial barriers, limiting the Registry of Deeds from seeking judicial redress and resolution of conflicts stemming from diverse interpretations of statutes affecting the Registry of Deeds funding and authority. It is all too obvious that the Registry of Deeds' attempts to seek judicial review and recourse can be all too easily thwarted based not on the soundness of legal facts and arguments, but rather on the disparity of funds and failure of means to elevate those legal facts and arguments so that they may be heard by and decided upon by the court. So we did make efforts. That went in July to the county commissioners. And again, the argument that we didn't substantiate, or they kind of act like they didn't know why I needed legal monies. For the very same reason they have independent legal counsel, the registry should have independent legal counsel.
Can I ask you a question about the relief that was ordered? Do you agree with what I believe counsel for the other side stated, which is that all the transfers you've requested have now been satisfied?
When I say satisfied, what happened to the last one, and I know it went up to you as the single justice, we had relief from Justice Sachs, who said he believed that we had a substantial, that the register had a substantially better chance of presiding. Because the stay wasn't granted by the trial court judge, Judge Cahill Lane. It was granted by another judge, even though Judge Cahill Lane was in the building. That's another story for another day. But when Judge Sachs, he made that decision, that was in May. Then they appealed it, and it got to the single justice, to you, sitting in Suffolk County. By the time that filtered down, the fiscal year had ended, June 30th. So when they said, it's not that we don't want the money, we couldn't use it because once June 30th comes, the fiscal year is over. And after you made your decision on June 3rd, 2024, they still went back to the appeals court trying to delay your decision, and Judge Hand said, stop filing recursive motions. So even though we fought to get access to the money, we never got it in 2023 because the fiscal year ended. And in fiscal 24, the fiscal year ended. So again, this year, we need help. The case is still going on.
So this last sentence in the order that says, to the extent that the transfers in this decision remain outstanding, the defendants are ordered to implement them. Is that still at issue in this appeal?
anything with this county director is an issue. There's just, there's just no cooperation. So we will wait and see. I haven't made a transfer.
I'm not looking for an argument here. I'm looking for fact. Are there any remaining transfers, outstanding transfer requests?
We're early in the fiscal year. We're debating that. It was hard to make that request when not 1 week after my primary win on September 3rd, they voted the county budget. They invited me over and cut my budget by $70,000. So it's a little early in the fiscal year for me to see. If I have to, I will. We need help. I mean,
I guess I'm not clear. The judge said, to the extent that the transfers in this decision remain outstanding, and then orders the defendants to implement them. I take it you're telling me there are none of the transfers identified in the judge's decision remain outstanding.
Because the fiscal year ended.
Because the fiscal year
This
ended.
year, I would try to use that same language, but it's hard to do when they keep, retaliating and cutting your budget. And again, I would just urge the court, I think it's common sense that the legislature intended that, you can't call a budget vote every week or every day, that they gave authorized officials discretion. And the county seems to accept the authorized officials, who are unelected. But not that that means I'm any better than anyone else, but it would be nice as an elected official running the second busiest registry of deeds in Massachusetts that I could focus on that out of 21 and that they be respected. So I think Judge Cahill Lane argued the decision better than I on page 10 of his decision when he in essence writes, again, I'm summarizing, the register is in the best position to make these registry decisions on behalf of the public that elected him. So I believe the statutory language and common sense should prevail, and that this honorable court hopefully rules based on the very unambiguous statute that's before you.